Welcome to the Real Free News Podcast. Today, 14th Amendment's Birthright Citizenship and Due Process Quagmire. The United States Constitution originally established a republic designed for white Europeans of good character, as codified in the Naturalization Act of 1790, which restricted citizenship to free white persons. This framework maintained racial homogeneity for over a century and a half. The 14th Amendment, ratified in 1868, shattered that design by introducing universal birthright citizenship and due process protections that extend to every person within the jurisdiction, regardless of entry status. Birthright citizenship automatically confers full citizenship upon any child born on American soil, including those of undocumented parents, creating an unbreakable anchor for chain migration. Due process guarantees hearings before deportation, producing a backlog of millions of cases that delays removal for years. These clauses transformed the nation from a controlled white European polity into a magnet for global migration, where entry alone triggers irreversible legal claims. The 1790 Act operated effectively until 1952, when the Immigration and Nationality Act eliminated explicit racial preferences in naturalization. The 1965 Immigration and Nationality Act further dismantled national origins quotas, shifting immigration toward family reunification and skills, dramatically increasing non-European inflows. Public ignorance of these legal realities remains profound. Most Americans believe Congress can simply legislate away birthright citizenship or expedite deportations without constitutional barriers. Polls reveal that only 31% recognize the 14th Amendment as the source of birthright citizenship, while 68% assume statutory reform suffices. This misunderstanding fuels false hope that electoral victories or executive orders can restore the original vision. Demographic transformation accelerates under these protections. Approximately 250,000 children are born annually to undocumented parents, each instantly a citizen entitled to sponsor relatives upon reaching age 21. Chain migration compounds this effect, with family-based visas comprising 74% of legal admissions. The Due Process Clause, reinforced by the Fifth Amendment, mandates individualized hearings, resulting in a 3.7 million case backlog and average removal timelines of 4 to 7 years. Even maximum enforcement can deport only 1 million non-citizens annually, yielding a net migrant gain of hundreds of thousands yearly. The 14th Amendment's clauses operate as an unassailable fortress. Supreme Court precedent in United States v. Wong Kim Ark established birthright citizenship for children of non-citizens, and Plyler v. Doe extended due process to undocumented persons. No statute, executive order, or lower court ruling can override these holdings. Reinterpretation requires 5 justices to overturn century-old precedent, an impossibility given current composition. Amendment demands 2/3 of both congressional chambers plus ratification by 38 states, a threshold never approached in 30 attempts. Enforcement within existing constraints offers the sole practical avenue. Sealing borders prevents new births on soil, while expanding detention, judges, and expedited removal accelerates processing of those already present. E-Verify mandates and local partnerships target employment, inducing self-deportation. Yet these measures address only non-citizens. The 45 million U.S.-born Latinos remain permanent citizens. The original constitutional order, tailored for white Europeans, cannot be restored without dismantling the 14th Amendment, a feat beyond political reality. This analysis exposes the irreversible legal architecture that has redefined the nation. The 1790 framework preserved ethnic continuity. Post-1868 amendments dismantled it. Public awakening to constitutional permanence is essential, as illusory legislative fixes distract from enforceable realities. Maximum border security, judicial expansion, and non-citizen removal constitute the only viable response. The Republic's demographic destiny was sealed in 1868, and only rigorous enforcement can mitigate its consequences. Part 1. The 1790 Act and Racial Homogeneity. The Naturalization Act of 1790 explicitly limited citizenship to free white persons of good character, establishing the United States as a republic for white Europeans. This law governed naturalization for 162 years, maintaining demographic continuity through racial exclusivity. Amendments in 1870 extended eligibility to persons of African nativity or descent, yet preserved the white core by excluding Asians and Native Americans. Court rulings in Ozawa versus United States and Thind versus United States reinforced this framework by denying citizenship to Japanese and Indian applicants on racial grounds. The system operated without contradiction until the Immigration and Nationality Act of 1952 eliminated explicit racial bars, marking the first race-neutral naturalization policy. This 162-year racial gatekeeping aligned with the founders' vision. The Constitution's 3/5 clause and absence of universal suffrage reflected an assumption of white European dominance. Immigration remained minimal and predominantly Northern European, with annual inflows below 300,000 until the late 19th century. The 1790 Act ensured that new citizens assimilated into an existing ethnic majority, preventing dilution of cultural and political control. The 14th Amendment introduced no conflict with naturalization laws, as its birthright clause applied only to those born on soil, not immigrants seeking citizenship. The 1790 framework continued unchallenged in its domain. Public policy debates of the era focused on slavery's legacy, not mass non-white immigration, which remained negligible. The Act's longevity demonstrates its effectiveness in preserving the Republic's original character. The 1952 Immigration and Nationality Act retained national origins quotas favoring Europeans, but removed racial tests for naturalization, allowing limited Asian citizenship. This shift responded to Cold War optics and civil rights pressures, not domestic demographic demands. Quotas still capped total immigration at 154,000 annually, with 70% allocated to Europe. The law preserved restrictionist intent while ending overt racial language. The 1965 Immigration and Nationality Act dismantled the quota system entirely, replacing it with hemisphere caps and family reunification preferences. Immediate relatives of citizens gained unlimited visas, while per-country limits of 20,000 applied universally. This reform shifted inflows from Europe to Asia and Latin America, with non-European admissions rising from 10% to over 60% by 2000. Family-based visas now dominate, comprising 74% of legal immigration. The 1790 Act's racial exclusivity prevented such transformation. Its amendments maintained white priority until 1952, when geopolitical pressures forced race-neutral language. The 1965 Act completed the reversal, prioritizing global equity over ethnic preservation. The original law's 162-year run proves that controlled, race-conscious naturalization sustained the founders' republic. Its demise opened the nation to demographic reconfiguration that no subsequent restriction has reversed. Part 2. The 14th Amendment's dual catastrophe. The 14th Amendment's Citizenship Clause grants automatic citizenship to all persons born on United States soil and subject to its jurisdiction, irrespective of parental status. This provision instantly transforms 250,000 annual births to undocumented parents into permanent citizens. The Due Process Clause mandates hearings before depriving any person of liberty, extending procedural protections to non-citizens, and creating a 3.7 million case backlog. Together, these clauses form an impregnable barrier to demographic restoration. Birthright citizenship operates as an irreversible anchor. Each child born to undocumented parents secures citizenship, enabling sponsorship of parents at age 21 under family reunification provisions. This chain migration mechanism has generated 1.2 million green cards since 2015, with 74% of legal admissions now family-based. The clause's universal application, affirmed in United States v. Wong Kim Ark, admits no exceptions for illegal entry or temporary presence. Due process compounds the crisis by requiring individualized hearings before deportation. The Executive Office for Immigration Review processes cases at a rate yielding 4 to 7 year delays. Even maximum enforcement removes only 1 million non-citizens annually, offset by continued inflows and births. The Fifth Amendment reinforces this protection for federal actions, ensuring no mass expulsion without procedural compliance. The amendment's drafters, white Republican abolitionists, intended to secure citizenship for freed slaves and overturn Dred Scott v. Sandford. Congressional debates reveal no contemplation of mass non-white immigration, then statistically insignificant. The broad phrasing, all persons, reflected moral universalism, not foresight of future migration patterns. This overreach, designed to prevent Southern reprisals against freedmen, now facilitates global demographic entry. Supreme Court precedent locks the interpretation. Wong Kim Ark established birthright for children of legal residents. Plyler v. Doe extended protections to undocumented persons. No lower court or executive action can contravene these holdings. Reinterpretation demands 5 justices overturning 125 years of stare decisis, a threshold unattained in 30 legislative attempts. The clauses interact to perpetuate expansion. Birthright creates citizens who sponsor relatives. Due process delays removal of sponsors. Approximately 45 million U.S.-born Latinos, products of this cycle, remain untouchable. Naturalized citizens, another 22 million, retain status absent individual fraud, affecting less than 0.5% annually. Enforcement within the amendment's confines offers limited mitigation. Border sealing prevents new births. Judicial expansion accelerates hearings. Yet these measures address only non-citizens, leaving the core demographic shift intact. The amendment's moral intent for 4 million freed slaves now sustains 60 million non-European descendants, a transformation its authors never envisioned. Part 3. Public ignorance and political impossibility. Most Americans remain profoundly ignorant of the 14th Amendment's constitutional entrenchment. Polls indicate only 31% recognize birthright citizenship as a 14th Amendment provision, while 68% believe Congress can abolish it through ordinary legislation. 22% understand that due process extends to non-citizens, assuming deportation occurs without hearings. This misconception fuels expectations that electoral victories or executive orders can restore demographic control. Immigration concern has surged, with 55% ranking it the top issue in 2024, up from 40% in 2023. Yet support for birthright citizenship persists at 53 to 68% overall, with 90% among Democrats and 30 to 39% among Republicans. 51% now view illegal immigration as a crisis, but 70% consider legal immigration beneficial. This disconnect reflects failure to grasp the amendment's permanence. Repeal requires 2/3 of both congressional chambers plus ratification by 38 states. No proposal has advanced beyond committee in 30 attempts. The current Congress lacks even simple majorities for restrictionist bills, let alone supermajorities. State legislatures, divided between 27 Republican and 23 Democratic controls, render the 38-state threshold unattainable. Supreme Court reinterpretation demands 5 justices overturning Wong Kim Ark and Plyler v. Doe. The present 6-3 conservative majority cites these precedents favorably, and no case challenging birthright has reached docket. Lower courts uniformly uphold the amendment's plain text. Public awakening to constitutional reality remains critical. Misplaced faith in legislative fixes distracts from enforceable measures. Maximum border enforcement, judicial expansion, and non-citizen removal operate within existing constraints. Sealing entries prevents new births. Expedited hearings clear backlogs. Yet these address only 26 million non-citizens, leaving 85 million U.S.-born minorities intact. The 1790 Naturalization Act's 162-year racial framework demonstrates that demographic control once existed. Its 1952 termination and the 1965 quota abolition shifted inflows from Europe to Asia and Latin America. Non-European admissions rose from 10% to over 60% by 2000, a transformation the 14th Amendment now constitutionalizes. Political rhetoric promising simple repeal misleads constituents. Executive actions expand detention and raids, but cannot touch birthright citizens. State-level resistance, such as sanctuary defunding, yields compliance or federal override. The amendment's supremacy, affirmed in Cooper v. Aaron, ensures enforcement through federal marshals if necessary. Part 4. Enforcement as the sole viable path. Maximum enforcement within the 14th Amendment's constraints offers the only practical response to demographic transformation. Sealing borders prevents new birthright citizens. Accelerating due process removes existing non-citizens. These measures cannot undo past grants, but can halt future expansion. Border security has reduced Southwest encounters by 95% since 2024, with 7,181 monthly crossings in early 2025. Remain in Mexico policies and expedited removal at ports of entry return 80% of claimants. Military deployment and physical barriers eliminate entry points, ensuring no new pregnancies on soil trigger citizenship. Judicial expansion addresses due process delays. The 2025 appropriations bill funds 10,000 additional immigration judges and 100,000 detention beds. Expedited removal nationwide processes 70% of cases within 90 days. Self-deportation incentives, offering $1,000 plus airfare, have induced 500,000 voluntary exits. E-Verify mandates and local partnerships target employment. Nationwide implementation removes 9.7 million undocumented from jobs, compelling departure. 287G agreements empower state police to initiate removal, achieving 3,000 daily arrests. Data fusion from social media and entry records enables predictive targeting. These initiatives deport 1 million non-citizens annually, triple the previous record. Over a decade, 20 million removals become feasible, reducing the undocumented population by 80%. Yet 45 million U.S.-born Latinos and 22 million naturalized citizens remain permanent. The 1790 Naturalization Act's racial exclusivity prevented such accumulation for 162 years. Its 1952 race-neutral replacement and the 1965 quota abolition opened inflows the 14th Amendment now protects. Birthright citizenship and due process were crafted for 4 million freed slaves, not 60 million non-European descendants. Public policy must abandon repeal fantasies. 30 legislative attempts have failed. 38 state ratification is impossible. Supreme Court precedent locks interpretation. Enforcement alone operates within legal bounds. State-level measures complement federal action. 23 states mandate E-Verify for all employers. Others cut sanctuary funding. Local ordinances revoke licenses from non-compliant businesses. These pressures induce self-deportation without violating due process. The original constitutional republic, designed for white Europeans, cannot be restored. The 14th Amendment's universal clauses ensure permanence. Maximum enforcement, border sealing, judicial acceleration, workplace raids, mitigates future growth while removing existing non-citizens. This path demands sustained political will and resource allocation, but avoids constitutional confrontation. Conclusion: repealing 14th requires 38 states, zero chance in any foreseeable future. The 14th Amendment has irrevocably altered the United States from a white European republic into a multi-ethnic nation through birthright citizenship and due process protections. The 1790 Naturalization Act sustained racial homogeneity for 162 years by limiting citizenship to free white persons. Its framework, amended but not repealed until 1952, aligned with the founders' vision of a controlled polity. The 1965 Immigration and Nationality Act completed the transformation by abolishing national origins quotas, shifting inflows to non-European sources. Birthright citizenship grants instant citizenship to 250,000 children born annually to undocumented parents, each capable of sponsoring relatives upon reaching maturity. Due process mandates hearings before deportation, producing a 3.7 million case backlog and removal timelines of 4 to 7 years. These clauses, intended to protect 4 million freed slaves, now anchor 60 million non-European descendants. Public ignorance sustains false hope. 68% believe Congress can legislate away birthright citizenship. Only 31% recognize its constitutional status. Repeal demands 38 state ratifications, a threshold never approached. Supreme Court precedent in Wong Kim Ark and Plyler v. Doe cements universal application. No executive order, statute, or lower court can override these holdings. Enforcement within existing constraints offers the sole remedy. Border sealing prevents new births. Judicial expansion and detention capacity accelerate removals. E-Verify and local partnerships target employment, inducing self-deportation. These measures can deport 20 million non-citizens over a decade, reducing undocumented presence by 80%. Yet U.S.-born and naturalized citizens remain permanent. The original constitutional order cannot be revived. The 14th Amendment's moral universalism, crafted to prevent Southern reprisals, now facilitates global demographic entry. Its drafters never contemplated mass migration from Latin America or Asia. The 1952 and 1965 Acts dismantled the 1790 racial gatekeeping, and the 14th Amendment constitutionalized the outcome. Political focus must shift from repeal to execution. Maximum border security, judicial funding, and workplace enforcement operate legally. State-level mandates and sanctuary defunding complement federal action. These steps halt future growth while removing existing non-citizens. The Republic's ethnic character, preserved for 162 years, ended with race-neutral laws and universal citizenship. Public awakening to constitutional permanence is essential. Legislative fantasies distract from enforceable realities. The nation faces a choice: rigorous enforcement to mitigate transformation or acceptance of irreversible change. The 14th Amendment stands as the final barrier. Only its constraints define the possible. Thank you for listening to the Real Free News podcast. Like, share, subscribe, and comment on the Quagmire. Visit realfreenews.com for more Real Free News content like this podcast, and see you next time.